for rent on this property. It also significantly impacts what one can sell this property for. The cards that were provided along with this, with the affidavit, they don't match up to what this property is. Under the plaintiff, the defendants provided affidavits of indigency pursuant to General Law, Chapter 261, Section 27B, and are indigent and disabled pursuant to 261-27A. Under King, the all or any portion of the reasonable monthly rental value of the property can be charged for use and occupancy. The reasonable rental value of this property in circumstances when you have a wealthy plaintiff and a disabled indigent defendant and a low income deed writer should be based on a Section 8 type of rental evaluation. Frankly, the plaintiff has failed to carry the burden of providing a fair market rental value that anyone can apply to. The insufficient evidence, while the judge in the lower court did lower the plaintiff's request for use and occupancy from $3,500 to $2,780, he did that based upon nothing. There was nothing provided to show that there should be a reduction of almost $800. The judge just used his discretion to say, well, you raise an excellent point, so I'm going to lower it, but that doesn't even take into account what the actual fair market value is. You have no starting point for the judge to exercise that discretion when the valuation that is provided by the plaintiff is so out of whack with the realities of the property. While I commend the judge for trying to take into consideration this, it still has to be grounded in some sort of reality. The question also becomes under what Your Honor is supposed to consider here. Your Honor is supposed to consider the fair market rental value, the merits of the defense, the amount owed per month on the mortgage, the number of months that no money has been paid on the mortgage, real estate taxes on the property, and the expected duration of the litigation and the respective financial conditions of the property. I'm going to start with the non-frivolous appeal. This mortgage was procured by fraud, and the judge in the summary judgment order claimed that there was no evidence, no admissible evidence of fraud submitted with our summary judgment opposition. However, what was provided was the sworn pleadings and the sworn answers to interrogatories from the 2016 Essex Superior Court case, which provided all of that evidence towards this mortgage being procured by fraud. It was simply discounted by the trial court judge or the summary judgment judge. And if this mortgage is procured by fraud, there is no mortgage to enforce.
I saw not only the documents, but also your motion for the judge to reconsider, which he denied. What do you say the documents from the Superior Court are alleged as specific to showing that there was fraud?
The documents actually show the answers to the interrogatories show that my clients were assured that this mortgage, this current mortgage, which was a refinance after a previous mortgage, were approved by the town of Boxford, approved by the low income housing authorities, and that they knew what they were doing and it was going to be handled. Now, at this point, the issue of whether the low income writer going forward has already been addressed by Chalet Properties with the town of Boxford. So that issue is cleared up, but not the lying to my client directly, which helped them go forward. My clients would not have moved forward with this mortgage had they known that it was not approved by the town at the time and it was out of whack with what they were able to borrow on the property due to the low income rider. This mortgage had to be approved by the town and the state prior to it going on record. It was not, despite the assurances of the originator.
Let's assume for a second, counsel, that you're correct, there was fraud. Does your client have to show that they were prejudiced in some way from that fraud? Because if Chalet has now basically fixed that issue, so to speak, I'm failing to see how your clients were prejudiced by it in any way. Does there have to be a showing of prejudice?
There's the showing is that there is no showing required for that, in that it would be they were induced into the contract by fraud, and the closing costs would be damages enough. They had to go through closing costs. That the closing costs that they paid out of that would be at minimum damages. So there is a showing of damages, even minimal at this point, but there's no contract formation because it's induced fraud in the inducement.
Okay.
Now, would Chalet Properties have an action later for subrogation, equitable subrogation? Yes, but that's not what we're here for now. What we're here to say is you have no contract and it should be wiped. If you want to go back, you can either go back to the originator, who doesn't exist anymore because of their bad business practices, or you try to be equitably subrogated to the previous mortgage. So this is it's a non-frivolous defense at minimum. If Your Honor had a question, that obviously raises it above non-frivolous. But the real issue that we have here also is a balancing of harms. This is a probably multi-billion-dollar trust that's involved in securitization of mortgages. My clients are disabled and are indigent. They have an appeal that is meritorious in this case. I attempted to have the judge look at the sworn interrogatory answers by my motion to reconsider. I failed in my duty or my job to convince the judge to look at that. And so here we are going to an appeal for the appeals panel. My clients are going to be severely prejudiced due to their disability. They're unable to provide for themselves, and that's partially why they were already in a low-income housing project. I think that in this kind of situation where a property, and I know it's a very unusual situation, I think that it's a section that the use and occupancy should be based upon a Section 8 type of valuation, to where what can you pay to support to live and during the pendency of this appeal. I think that they're very similar in those aspects. Section 8 housing recipients have a personal pay option that they must do based upon what they're physically able to pay. And in this situation, the house is encumbered by a low-income rider. And I think that the plaintiff has provided insufficient evidence of the fair market rental value of the property when you consider the low-income housing project rider that encumbers the property. The $3,500, if we were talking your standard situation, is probably a very good valuation. I have no issues with, I'm not taking issue with the credentials of the evaluator, but he didn't do a full job. And that's why we're here, is because the full job was not done. And so the judge had nothing to base that upon, what the reduction should be. And so he made a reduction, but he did so based on no evidence. And it's my contention that it's the plaintiff's burden to show what should be the fair market rental value of a property when seeking use and occupancy.
Are you suggesting that I should remand for that? Or do you suggesting that I should make use and occupancy 0 because the plaintiff hasn't met the burden?
I think you should make it 0 because the plaintiff has failed to make his burden, but I know the likelihood is that you will send it back down for a determination. But I would ask that you make it 0 so that my clients can pursue their appeal and assert their rights.
Thank you very much.
Thank you, Your Honor.
Attorney Bucci?
Thank you, Your Honor. I just am going to start with the fair market rental value. I understand Attorney McGuire's argument here regarding the deed rider and it being a low income situation. However, the statute is just it's fair market rental value and or use and occupancy. So while it wasn't taken into consideration, that's not necessarily part of the statute. Although, and I don't know what the lower court took into account in lowering the amount. I can only guess that maybe it was because of counsel's putting them on notice of the deed rider and his opposition. But for that, again, it's just the fair market value. It's not.
But wouldn't the market value of a property, if there's a restriction on a deed, take that into consideration about what fair market value is? Or shouldn't it?
I suppose that is possibly the case. However, it would be very difficult for anyone to guess what a person's mortgage payment might be if it was, right now. I would say, yes, it would make sense for that to be taken into account. And I suppose, should this be remanded, we would have to take a look at the approved mortgage payments prior to default. I certainly can bring that forward and present that to the lower court if it's remanded. And then just to touch on the amount, I believe that affidavits of indigency were provided. I don't obviously see those. However, I would imagine that those affidavits are something that the lower court also took into account while looking into the ability of them to afford the use and occupancy. And then just regarding the fraud issue, as we've discussed, or as Attorney McGuire has mentioned, my client has resolved the issue with the town, and they're the only ones that have standing to challenge anything regarding the deed rider. The former owners don't have standing to challenge the mortgage, and just because the mortgage previously was not approved, it was later approved. And because of that, an impermissible mortgage doesn't mean unaffordable. And the fact that the town and the DHCD later in their discretion approved it, it was, in their opinion, affordable. And typically they tend to be more concerned with the deed riders for the maximum resale value and not so much the affordability of a mortgage, although that certainly is a concern. But just again, on the fraud issue, it's our opinion that that's been resolved and there's no fraud, there's no damage to the defendants because they still, after the fact, the mortgage was still found to be permissible.
What about the argument? What about the argument which goes to what I asked regarding, does there have to be basically a damage amount? That the argument that it was fraud in the inducement. And under contract law, if there's fraud, and it makes the contract, i.e. the mortgage, improper.
So to that, I don't know. Well, so I don't know. Without looking at it in front of me, I don't know the exact fraud that was done. However, there was no. I truly don't know what the fraud was that induced them to do it. And I don't think that was something that was a problem, just because in the lower case, the lower case was the prior case has already been resolved. So there was nothing from that. And they were still in the same position as they were before.
Okay. I mean, the issue I'm having, the issue on appeal, as the judge found without really getting into it in the judge's decision, found it meritorious. The issue I do have is the amount. As Attorney McGuire said, I don't know where that amount came from. And I think there is a point of, if there is a restriction on a property, I certainly think that goes to what a market value is. The easiest example a 3-story home is different than a 1-story home as far as what market value is. And if there's a restriction on a land that says you can only have a 1-story home, then the market value, you can't look at a 3-story home. And I sort of equate that to what your expert did in this case. He didn't look, I think it was a he didn't look at the fact that there was a restriction on the property, which may in fact lower the amount. The issue I have to decide, frankly, is does that mean you haven't met your burden on what the proper use and occupancy is, and should it be 0, or can I remand that to the judge for further consideration, in order to take into consideration what the market value is, keeping in mind the restriction. So I will try to reach a decision on this as quickly as possible, and you will both be notified. Okay.
Thank you, Your Honor.
Thank you very much.